Just so everybody knows, the mics are hot and it is being live streamed on YouTube, and so it is there. Thank you. Not yet. Not yet. We'll let you know when.
All rise. The Court of Appeals for the 10th District of Texas is now in session. God save the Constitution and this honorable court.
You may be seated. We have two cases on the 9 o'clock docket today. Waco Court of Appeals being held in Waco, Texas. The two cases, when I call them, I would like announcements from the attorney or pro se with regard to one that is arguing the case. an announcement that you're ready, or if there are any preliminary issues that need to be taken up, in particular, if there are any exhibits of any type which we haven't been advised of, let me know. Usual protocol applies for courtroom. Please turn your cell phones to the off and silent, off or silent position. We do allow movement during the arguments. We only have 2 on the docket today. We may or may not take a break between them, but if you do need to move around, do so respectfully where the attorneys and the court are not distracted. The first case to be argued today would be Dr. Gill versus Goodson, 1023-00249.
Your Honor, I'm Gaines West, and I represent Dr. Gill, and here with me today is also my associate Hayden Gill.
Okay, very good to have you.
Thank you.
Your Honors, I represent Kelly Goodson. I'm John Paul Hopkins out of Conroe, Texas. My esteemed co-counsel Stephen Kerrigan has allowed me to speak for both of us.
Okay. Thank you, counsel. It'll be 20, 20, and 5 rebuttal. You do not have to take all the time. We may have questions during the course of the argument. Second case on the docket is Quinn versus Melton.
Good morning, Your Honor. Brandon Osler for appellant Patricia Quinn, and we're ready to proceed.
Thank you, counsel.
Good morning, Your Honor. Matthew Melton, pro se, and I'm ready to proceed.
Thank you, counsel, or pro se. All right, you may approach the lectern and proceed when ready.
Good morning, Your Honor. May it please the court. My name is Gaines West.
Hold on just a minute, Gaines. Is your clock running on your side?
It is not. There, it is flashing now. It's at 1943.
That's where you will begin.
Thank you,
You may
Your Honor.
proceed.
I'll start over. Good morning. It's good to be here in the 10th Court of Appeals, and may it please the court, I represent Dr. Corey Gill in this matter. Your Honor, this is a case that can best be characterized as a failure to rebut a presumption that the law gives us. I'll go over that in a minute. And then secondly, it's an if-only case. An if-only case, and I mean that in this sense. I don't think the appellees in this case really ever contemplated filing an expert report until the motions for dismiss started pouring in. There was another healthcare provider in this case, and they beat me by a day in filing, I think, the motion to dismiss. They were ultimately dismissed by the appellee. But they kept the case with us. And when I say it's an if-only case, it would have served them better to have had an expert report filed within 120 days, because there is a good reason for that 120-day report. And that good reason was summed up well by the Loasiga case. That's the 2012 Supreme Court case that I've cited in my brief, and the Lake Jackson case, its progeny, that came along right after it. These Supreme Court cases really settled the landscape for us. But they said this, it said, in balancing the respective rights of and burdens on claimants and medical and healthcare defendants, the legislature has determined that requiring claimants to bear the expense of obtaining and serving expert reports early in the healthcare liability claims is preferable to having parties incur substantial expense and devote considerable time to developing claims through discovery and trial preparation before a trial court determines which ones are meritless. It's an if-only case. The The case that I just referred to, the La Siga case, really does settle this landscape, sets the test, sets the presumptions. We get the presumption that this is a healthcare liability claim because it was brought against my doctor. He's a healthcare provider. And the pleadings that we got from the plaintiff, Ms. Goodson, was claiming that his conduct happened during the course of her care or her treatment. That gives us the presumption that these are healthcare liability claims. And the Lake Jackson case, the Supreme Court clearly then said the burden shifts. The burden then is on the plaintiff to show that that presumption can be overcome. It's a rebuttable presumption, but there are three tests that they must be able to get through. One, that there's no complaint about any other conduct of the doctor other than the alleged offensive conduct. Two, it was not consented to. And three, the only possible relationship between the alleged contact and the provision of care was the setting. And these are all and provisions. These are not or provisions. They have to reach all three of those to be able to get to over their presumption, over their to meet their rebuttable presumption. Now, let's look at what they brought to the court, the trial court. The plaintiff convinced this trial judge to not pay any attention to La Siga and Lake Jackson. I'm not sure how he was able to do that or how she was able to do that. But the trial judge here bought what they were selling and ignored clear Supreme Court precedent. Here's what they did. They alleged that Dr. Gill arrived an hour late for the procedure. That's at Clerk's Record 207. They alleged that Dr. Gill smelled like alcohol. That's at Clerk's Record 207. They alleged that Dr. Gill's medical license had been suspended. That's at Clerk's Record 208. Each of these allegations alone prevents Ms. Goodson from rebutting the presumption. Why? Because remember, the first test that La Siga says we have to follow is there's no complaint about any other conduct of the doctor. As a matter of fact, they made those three separate complaints. She did assert that it was non-consensual, so she would have complied with only one of the three, number two, but then number three has to conclusively establish the only possible relationship between the alleged conduct and the provision of care was the setting. Again, La Siga paves the way for us. In that case, there actually was a report filed. That was not an if-only case. Here, La Siga says the lack of information in that case, like the medical records, prevents Goodson from conclusively establishing that it was the setting. Here's the problem.
Counsel, how much do we have to look at the differential, I guess you would say, in the pleadings between the allegations of events, the allegations that have some legal significance, as in alleging that the conduct was in the course and scope of employment, to then where they proceed into the making the actual allegations of a claim, which the claims against the doctor had to do with assault and battery, and not framed in the context of negligence. Now, I understand the other defendants are out of the case at this point, and I don't know what an amended pleading would look like with them out of the case, but obviously some of those pleadings were necessary in the alternative for the purposes of vicarious or other liability in connection with a negligence claim.
Let me answer your question this way, Justice Gray. In the court below, there was no provision or development of evidence. There could have been. La Siga set that out. in their opinion, they said there is a way to bring evidence to the court. It said, the statute or the trial court may consider when the question is whether a claim is subject to the TMLA's expert report requirements, that would be this case. Thus, when making that determination, the court should consider the entire court record, including the pleadings, motions and responses, and relevant evidence properly admitted. This could include, but not limited to, reports such as those the plaintiff served here, medical records regarding examination or treatment of the plaintiff, if any, and the defendant's pleadings and explanation for how the contacted issue was part of medical care. They didn't do that. All you have on the record is the pleadings, and Losiega said, you can't just look at argument. You can't look at legal argument.
But we have the pleadings,
You have the pleadings.
and the pleadings assert that there was both anal and digital penetration. And how is that in the context of the statements made in Losiega that if there's no, I think, rational connection between it, the court is in effect entitled to rebut the presumption?
Well, one thing is you've got to be able to meet, or Ms. Goodson needs to meet all three of those requirements, not just one of those requirements. And you're speaking only to that care standard. Secondly, what we see here in Losiega is you cannot just look at the pleadings in the case. You need to look at the evidence as a whole. And they concluded in Losiega, even though there was a report filed, that there was insufficient evidence to be able to determine one way or the other. Because remember, Vanderwerf, and I've cited you to Vanderwerf, that's that case that the Fifth Circuit looked at. And the Fifth Circuit had those, the Vanderwerf case had those same salacious kind of allegations in it. But the problem is that they didn't have enough information to go in and find out whether those claims could have been part of the medical treatment. Just like here, you can't just look at the pleadings. You got to have a development of evidence. You have insufficient evidence on the record to be able to determine whether they could meet that rebuttable presumption standard. And so what we're saying is that
So your assertion then is that you have to have evidence to rebut the presumption, the allegations in the petition are not sufficient?
what I'm saying is that if you follow what Losiega, Lake Jackson, and Vanderwerf say, that there needs to be more information that you have in front of you. Now, just the mere pleadings alone do not carry that rebuttable presumption. And don't forget, they've also not met their rebuttable presumption standard on test number 1. And they have made all three.
I'm struggling with that because the allegations of facts, which may or may not apply to an individual claim, in this case, a claim of battery, that may be relevant to one of the other defendants that were in the case at that time. I'm struggling to see how the intoxication, hour late, has now lost his license, relates to her claim for assault.
Because they relate and they don't relate, but they relate in this way. They are making claims. Ms. Goodson is making claims other than the contact claim. And if there are other claims other than the contact claim, we clearly know from Losiega that she cannot then meet that test.
And see, that's where I'm struggling because I'm contemplating what the charge in this case might look like. And it's going to be a assault and battery charge based on at least the first of the claims. And then I could see maybe how a defense of permitted contact or consensual contact, but the allegations at this stage clearly seem to take that out of the mix.
Here's the problem. That's your actually reciting the argument in La Ciega for the claimant. Also in Vanderwerf, they made those same arguments, but those arguments were rejected by the Supreme Court. And they were condoned in that rejection by the Fifth Circuit. I understand your struggle because of salacious charges. Unfortunately, it's not enough. We've got a case where the presumption can't be overcome. And we have an if-only case. If only there had been a report filed, maybe you could be considering at this point, sending it back for a new report. Maybe a new report could solve that problem, but you don't have that here. The result of this case has to be 120 days has passed, then file a report. It's presumed to be a healthcare liability claim, and this case needs to be dismissed, returned to the court for a finding of the attorney's fees in favor of my client. The fact is, there is not enough information on the record as a whole for you to make a determination that this rebuttable presumption has been met. Remember this, because Goodson's claims involve allegations of assaultive conduct, very similar to Vanderwerf, very similar to La Ciega, that she alleges to have occurred during a medical examination for symptoms in an area that was in close proximity and anatomically connected to the location of the alleged assaultive touching. Sounds like Vanderwerf. And she has failed to produce any additional evidence for the record. She could have, she didn't. To provide additional context, she has failed to conclusively establish the record the law now under La Ciega requires a conclusive establishment that the only relationship between the alleged offensive conduct and the medical care was the setting. Goodson has failed, and thereby she is unable to establish two of the three elements to rebut the presumption, and her claims that her claims are not healthcare liability claims. As a result, her claims are healthcare liability claims subject to the requirements of Chapter 74, and her failure to timely produce an expert report mandates the dismissal of her claims.
So basically, you would require the doctor's report that says digitally penetrating someone anally or vaginally does not meet the standard of care.
What we would have to do, or what the court would need, would be more evidence to be able to make a decision as whether or not there's been a conclusive establishment of these tests and norms that La Ciega is requiring.
But isn't that the very burdensome procedure that Chapter 74 was designed to avoid, of getting into a pre-trial evidentiary determination of these disputed facts?
Well, you'll need to tell the Supreme Court that, because the Supreme Court in La Ciega told us clearly the way that they can do it. And I read you that portion of that court's decision that allows for the development of evidence, because this came specifically in question there. And in La Ciega, it said the statute does not similarly limit, meaning not like in the report, what a trial court may consider when the question is whether a claim is subject to Chapter 74's expert report requirements. So we have a little different way of looking at these issues, and the Supreme Court has said that's something you can do. And if they were going to try to rebut this presumption, they should have brought that in front of the trial judge, and they did it. And La Ciega clearly said, you can't just look at these pleadings, there's not enough evidence to determine conclusively that there is a rebuttable presumption. Their burden has been met. So for all those reasons, we would ask you to return this to Judge Rick and tell him The only option he has is to dismiss this case and determine the attorney's fees for my client. Thank you.
Thank you, counsel.
Please score your honor.
You may proceed when ready.
Thanks, sir. Your Honor, John Paul Hopkins for Kelly Goodson on behalf of myself and Stephen Kerrigan, who's not here today. And y'all are asking the right questions on this, and it's, and the pleadings show that this is a case of sexual assault and battery. That's the case. These other facts that they throw in there, there are a myriad of facts that you could tie to, the fact, just the presence in a healthcare facility is gonna lend argument for anything that happens while you're there has something to do with healthcare. But as, Justice Smith asked the question, do you need an expert report that sexual assault violates the standards? And you don't, and there's no standard of care for sexual assault. That's why you don't need an expert, and that's why this doesn't fall under the TMLA. Everybody knows you can't, the only answer is you just can't. Sexual assault's never proper. Mr. Gill knows that. It's just common sense. When you step outside the lines, when you start drinking, if you're a doctor, you start drinking on the job and seeing patients and then taking liberties that you shouldn't, you know, you're well without your bounds. And basically you spit out the Hippocratic Oath whenever you took that first drink. And it shouldn't be a shield to protect you because you've abandoned that whole creed. And now, you not only Kelly Goodson, but there are others that have suffered because of this. To hide behind the tort reform and say that, well, you know, you gotta go get experts and you probably can't afford it to bring this case. Well, that's what they're hiding behind, the defense is in this case. There's no question. There's no evidence at all. There's nothing in the pleadings that says that my client didn't consent. We admit that it was at a healthcare facility. So the course of treatment is the only option. There are three elements, and Louis Sega case is great and it does provide the framework. But there's a case, and I'm sorry that I haven't updated the brief, out of the First Court of Appeals, and that was just decided in March. At the end of March this year, and that is the opinion was issued March 22nd of this year, and it is number 0123000541 CV. That's out of the First Court of Appeals in Houston. The name of the case is Azul Shirazali Jaffer, MD, and then his business entities, Plastic Surgery, as the appellants. And Michelle Mason is the victim in that case, just like Kelly Goodson. And if you read this opinion, you could just change out the names. Put Kelly Goodson where Maestas is, and you're gonna have the same arguments that are being presented by the defense that were summarily denied in that case. The same situation there. Trial court denied to dismiss the case based on the same arguments that Mr. Huff makes today. And because they found that sexual assault isn't covered under the Texas Medical Liability Act. Under some courts it's ruled differently, but this is the First Court of Appeals, and citing from the opinion, it's the same argument. And it says to look at the underlying nature of the claim rather than its label. Well, the amended petition, the live pleadings in front of you, only don't assert any healthcare liability claims. They assert that they recite the facts, and the facts clearly show it's an assault and battery, and this is a tort, and it's not covered under Chapter 74. And, you know, I'm no scholar, I'll be honest with you, but, and reading up on this and reviewing, that's not, nobody's